Good morning, everyone. Thank you for joining the first in the Landmark Chambers Planning High Court Challenges webinar. This is therefore part one. We're delighted to see so many of you joining us, and we hope you find our presentations and discussions to be useful and informative. The second part, I'm asked to say, will take place next Monday on the 20th of November. And the third and final part will be the Monday after that, the 27th of November. Please do register for those webinars if you haven't already. I'm David Elvin KC, and I'm proposing to chair the seminar today, and I'll be joined by Rupert Warren KC, Richard Turney, Natasha Jackson, Joel Semakula, and Charles Bishop, who I will formally introduce shortly. Just a couple of housekeeping matters before we start. Microphones are all automatically muted, so please don't feel the need to adjust local settings. We welcome questions throughout the session. Can you please submit them via the Q&A button, which will be either at the bottom or top of your screen usually. If you'd like to remain anonymous, please make sure you tick the Send Anonymously box before submitting your question, and we'll try and answer as many of those questions as we can at the end of the presentations. This webinar is being recorded. You'll get a link to the presentation and the recording shortly after we finish the event. And please, if your connection is lost at any stage during the webinar, please rejoin by clicking on the original link. So if we can start now with the first presentation. The first presentation is by Joel Semakula on recent developments in habitats. His practice covers all aspects of planning law, and he appears before a range of tribunals, either on his own account or being led. Recent instructions, including acting for national highways in the A66 Transpennine DCO, where he's advised on a range of matters, including habitats. And he's presently finishing off a 4-week inquiry in Uckfield being led, so no doubt he'll be deep into writing the draft closing speech. Joel.
Good morning, everybody. I'm just waiting for my own camera to show up.
You're visible. Oh, you've just turned it off.
Perfect. Sorry, I guess you guys can see me. I can't see myself. That's probably for the best. Hi, everybody. As David says, I'm here to do the first case law review of the series. I've set out there some of the key themes I'll be addressing on the slides. And I've set out next to some very cute dormice because I wanted to make you all feel warm and fuzzy on this Monday morning. And of course, those are a species that benefit from the types of protection that the habitats regulations provide. So on my count, there were 6 cases that came out this year, which considered the provisions, particularly of the 2017 habitats regulations. I've only got 15 minutes. And so my focus is on probably the 4 cases that, in my view, have something the most interesting to say for practitioners in this area. But as with everything in planning, whether this is indeed interesting enough is a matter for my own judgment, challengeable only on Wednesbury grounds. I'm not going to be talking about the nutrient neutrality announcement that came out in September, just because time's very limited. I'm starting with Regulation 63. So Reg 63 requires that there must be an assessment by the competent authority as to whether a project or plan is likely to have a significant effect on a European site, providing it is not directly connected with or necessary to the site's management, whether in combination with other plans or projects alone. That's Regulation 63's 1. And so if that low screening threshold is passed, the competent authority must carry out an appropriate assessment. And so the first case I want to talk about is a case called Sahota, which actually came out at the end of last year in December of 2022 in the Court of Appeal. The facts aren't particularly important, but the key issue for the court was whether on the facts an appropriate assessment was required. I think it's helpful because the Court of Appeal here just reiterates the guidance around how they deal with these types of challenges when they do arise. And I've set out the key points there on the slide. Of most importance, I think, for me, is that whether a plan or project would adversely affect the integrity of a European protected site is always a matter of judgment for the competent authority itself. where you've got a legal challenge to a competent authority's decision, that being its performance of its Reg 63 duty, the court's function is supervisory. The opinion of bodies such as Natural England must be given significant weight. But as we're all used to in this area, a competent authority can lawfully disagree with that opinion and depart from that advice, but it has to give cogent reasons for doing so. And as you'd expect, the court will give appropriate deference to the views of any expert regulatory bodies who provide them. And so think about how that's been applied, looking at that guidance. The second case I want to look at is C.G. Fry and Son. That's a judgment of Sir Ross Cranston sitting as a High Court judge. This case was about the potential adverse effects on the Somerset Levels and Moors Ramsar site, and that site is shown there on the slide, from the claimant's proposed housing-led development on land east of Wellington in Somerset. I was going to do the accent and chose not to. C.G. Fry and Son, the claimant developer there, sought to quash a decision by a planning inspector, refusing to discharge conditions attached to a planning permission for mixed-use development in Somerset, because there had not been an appropriate assessment under the 2017 regulations. The claimant argued that the inspector wrongly construed the regulations and should not have applied Regulation 63 to the discharge of conditions on a reserved matters approval. He further argued that even if Regulation 63 did apply, the scope of the appropriate assessment should reflect the scope of the conditions being considered. Now, in the court's view, on a strict reading of the regulations, the assessment provisions were confined in their application to the planning permission stage. However, in the court's view, the court went on to say that the assessment that those provisions did cover the discharge of conditions for a number of reasons. First, Article 6.3 of the directive required a project should not be agreed until an appropriate assessment had been undertaken. And so that requirement had been accepted as binding in CJEU proceedings prior to the UK leaving the EU, such that it survived and continued to have effect following Brexit. That came from the Withdrawal Act. The second is that a planning consent was part of agreeing a project when it was necessary to implement a development. In this case, the discharge of pre-commencement conditions was a necessary step in the implementation of the development. An appropriate assessment had not been undertaken, and the inspector had determined that he could not therefore discharge the conditions. And the court found that conclusion was consistent with Article 6.3 of the directive. The regulations here demanded a purposive interpretation so that the appropriate provisions of Regulation 63 applied to a subsequent consent stage, including reserved matters applications and the discharge of conditions. And it was that purposive interpretation, to finish here, that enabled the court to come to the conclusion that a competent authority must conduct an appropriate assessment before any consent, permission, or other authorization was given for a project. So where, as in the C.G. Fry case, you've got a multi-stage consent process, there was no agreement until, for the purposes of Regulation 63, until reserved matters were granted or conditions discharged. So what this case makes clear is that an appropriate assessment could apply at the reserved matters or discharge of conditions stage, even where there's been a grant of outline planning permission, where the subsequent approval is the actual implementing decision. And then if we return to what I said there, the claimant's argument around the scope of Regulation 63 and the claimant's attempt there to limit that. Here, the judge held that Regulation 63 required an appropriate assessment to consider the implications of the whole project, not just the implications of the part of the project to which the consent related. So it wasn't enough to just simply look at the impact of the condition being discharged. So when we're revising here, I think it's worth considering not just whether an assessment is required at the outline stage, but whether some aspect at a later stage may indeed render it necessary. Case number 3, wild fish conservation, I think came out, I think it was July, August of this year. And that's a judgment of Mr. Justice Holgate. Now, in this case, you had conservation charities, which issued 2 sets of proceedings claiming judicial review of the storm overflows discharge reduction plan, which was published by the Secretary of State pursuant to Section 141A of the Water Industry Act 1991. There, the plan set 3 targets. The first was to protect the environment. The second was to protect public health in designated bathing waters. And the third was to ensure storm overflows operated only in unusually heavy rainfall events. Those targets were specifically for water companies, regulators, and the government working towards eliminating the harm from storm overflows. Here, the question before the court was whether the plan is a plan which is likely to have a significant effect on a European site or a European offshore marine site. You may remember that when I put regulation 63.1 on the slide, we're talking about either a plan or a project. And the claimant's Wildfish, the claimant here, his argument was that on the basis that it was, that plan could not be agreed to without carrying out an appropriate assessment of its implications for the sites in view of the site's conservation objective. And I say sites there, using the plural on purpose. It was common ground here that no such assessment had been carried out. The defendant's position was that the plan was not a plan falling within or captured by Regulation 63. Now, part of the difficulty for Mr. Justice Holgate here was that the Habitats Directive, nor the 2017 regulations, neither of these contains a definition of a plan. And there's also relatively little jurisprudence on this point. The judge here found that the plan merely sets national targets for storm overflows generally, and the identification of capacity upgrades for individual sewer systems depended upon improvement programs required by Ofwat, and the linked variations in environmental permits made by the Environment Agency. The permitting decisions here would be subject to appropriate assessment under the 2017 regulations where required. And so here there was actually no specific link between the plan and any specific European site. The judge accepted the defendant's submission. The plan is a statement of the general political will of the Secretary of State. It's a high-level strategic document which does not identify where those sewer upgrades will be required in order to meet the policy targets, because in general, that remains to be assessed over a number of years running up to the target years. As such, again, here we had no link with any specific site. So on that basis, the judge found the plan does not fall within the ambit of the appropriate assessment provisions in the 2017 regulations. The judge here also found it relevant that Wildfish was unable to explain how the other tests that from the habitats regulations could be carried out, namely regarding the test regarding the absence of adverse effects on the integrity of relevant European sites, having regard to the conservation objectives, and also the Europe test, how those could be applied to this plan where you had an absence of proposals for upgrades on specific sites. So I think what this tells us in terms of, in order for a plan to be caught by Regulation 63, what we're looking for is that plan should carry a degree of precision in the planning in question, which calls for an environmental assessment of their effects. We're looking for a link with a specific European site. And here there's clearly an attempt here to limit the scope of what projects, of what plans here would actually be covered or required to be assessed. And the final case here is a Sizewell case, another judgment of Mr. Justice Holgate. And there's two specific grounds that are of relevance here for the purpose of this case law update. Let's go back one, apologies. So this was a rolled up hearing and involved the permission to apply for judicial review of the Secretary of State's decision here to make the Sizewell C development consent order. The first ground that we want to talk about here was that in breach of Regulation 63, the Secretary of State had failed to make an appropriate assessment of the implications of the project here for European sites because he wrongly excluded from the project the permanent potable water supply solution, without which the project is incomplete and cannot function. And as at the date of the decision to make the order, that solution would potentially give rise to further impacts on protected areas which have not been assessed and could not be ruled out. Effectively, that ground one, the failure to conduct again an appropriate assessment. The starting point here is that the question of what is the project for the purpose of Regulation 63 as opposed to the plan, which we were talking about before, in any particular case, is a matter of judgment for the decision maker here, the Secretary of State. The issue for the court was whether the defendant took into account a consideration which was legally irrelevant, and if not, whether his judgment was otherwise irrational. And all of us who advise on these types of claims are well aware the threshold for irrationality in the making of such judgment is a difficult obstacle to surmount. One thing the court was particularly looking for here, and something that the courts have been astute to, is this concept of salami slicing. So that being the device of splitting a project into smaller components that fall below the threshold for assessment. Well, Mr. Justice Holgate found that's not what had happened here. This wasn't a case of slicing. And the claimant submitted that, and in response to the claimant's submission, the defendant had taken into account a number of irrelevant considerations. Well, the claimant sought to base its criticism upon the case of Ashchurch, I think with which many will be familiar. Some of you may know that as the Bridge to Nowhere case. There in Ashchurch, the court had found that the council's decision was its failure to even to consider whether the bridge formed an integral part of a wider project for the purpose of the EIA regulations, and that was the central flaw. But here, that's not what's happened. Here, the defendant had considered whether the provision of a permanent potable water supply formed an integral part of the Sizewell C development and concluded that it did not. And the court found that in reaching that conclusion, that it had the defendant had not taken into account any relevant considerations. He'd indeed had regard to a number of relevant matters in the exercise of his judgment, and there was no basis for finding that the approach had been irrational or unlawful. And I think on the slide there, you see what Mr. Justice Holgate says here about his concern about the wider implications, namely the fact that nearly all development a lot of development talks about has a need for the supply of utilities, such as the supply of water. And the utilities companies need to make additional provision to be able to supply existing and new customers in the future. Does not mean that that provision or its method of delivery is to be treated as forming part of each new development. The consequence he was concerned about is that mainly where a new supply has yet to be identified by the relevant utility company, decisions on those development projects would have to be delayed until the company is able to define and decide upon a proposal, which would lead to sclerosis in the planning system, which is exactly what we're trying to avoid. And I've got a couple more minutes, so just very quickly, Regulation 64, before I move on to the second ground here, is that look, if it cannot be ascertained that the project will not adversely affect the integrity of the European site, that being that the appropriate assessment is negative, then the authority will need to consider whether the project should nevertheless proceed pursuant to the derogation power under Article 6.4. And the exercise of that derogation power has three preconditions, but I'm only going to focus on the first of these, namely that there must be no reasonable alternatives to the project. And so this was ground 4 in that Sizewell, in the Sizewell case. Effectively, the Secretary of State concluded that the project would have an adverse effect upon the integrity of the relevant SPA. And according under Regulation 64.1 of the 2017 regulations, the Secretary of State had to be satisfied that there were no alternative solutions. And that was indeed his conclusion. The claimant had an interesting argument here. The claimant's position was that the decision maker must consider alternative solutions which could fulfill the core policy objectives or the central policy objectives, these being legal terms of art. The central policy objective should not be drawn so narrowly as to curtail the ability of the habitats regulations to inhibit unnecessarily harmful development in favor of less harmful alternatives. The claimant here submitted the policy goal of providing nuclear power is artificially limiting to the extent that it cannot be logically characterized as central. By contrast, the provision of comparatively clean energy does qualify as a central policy objective because that goes to the heart of what is sought to be achieved. And the claimant's position was that the lack of nuclear energy is not a problem. Instead, it was a lack of clean energy, which is a problem, capable of a range of alternative solutions. And so it is the provision of clean energy which qualifies as a central policy objective. Again, here, when determining whether there's an alternative solution, the standard of review in Regulation 64 is the Wensbury standard. And subject to those principles, it's a matter for the decision maker to determine the relevant objectives which need to be met and which alternative solutions would or would not meet that need. And just to close here, Mr. Justice Holgate here started first with the national policy statements and found they included the generation of clean energy, but the central objectives of these policies is not limited to that aim. They also include a diversity of methods of generation and security of supply. And the government sees new nuclear power as an essential component of those objectives, just as wind and solar power. And the judge found that the claimant's argument depends upon an illegitimate attempt to rewrite the government's policy aims by pretending that the central policy objective is at a higher level of abstraction, namely to produce clean energy. And the judge is quite critical here, saying it's not the role of the claimant or the court to rewrite government policy or to airbrush objectives of that policy, which are plainly of central or core or essential importance. So there we ended up with the application for judicial review being refused. And I think I'll end it there.
Thanks very much, Joel. Just worth mentioning, of course, that the Fry case is going to the Court of Appeal. It's also worth mentioning, and we can pick this up later, or Joel can pick it up later in questions, but the nature of subsequent consents that appears on the basis of Fry to require appropriate assessment is those consents which are necessary to the implementation of the planning permission, which seems to mean matters subject to Grampian or similar type of assessment, but we can discuss that further if people are interested in doing that. The next paper is from Charles Bishop. Charles practices across all areas of planning, environmental and public law, and regularly appears in court in these areas. His recent experience includes acting as junior counsel in the Wild Fish case, in the judicial review of the Storm Overflows Discharge Reduction Plan, and in recent litigation concerning the use of MOD sites for asylum accommodation, relying on emergency permitted development rights. Charles.
Thank you, David, and good morning, everyone. I'm going to be talking about amending and interpreting planning permissions and looking at some of the recent case law on that, and in specifically looking at Section 73 of the Town and Country Planning Act 1990. But starting first with interpretation of planning conditions and planning permissions, there's now quite a well-established body of case law, most of which comes from the Supreme Court at this point, in setting out principles in relation to interpretation of planning permission. But in conjunction with Trump International Golf Club case and Lambeth and Secretary of State case, which set out the principles, we've now got two more Supreme Court decisions, both at the back end of last year. First is I'm going to look at as DB symmetry, but we've also got the Hillside case, which is familiar to everyone, I'm sure, on this call. The DB symmetry case concerned a condition which it was said required the adoption as public highway of an access road, and the Supreme Court had to interpret what the permission said. There was a second question whether you could actually impose a condition requiring a public highway as a planning condition, but that isn't relevant for these purposes. What was useful is that the Supreme Court summarizes the principles in relation to interpretation from Trump International, from Lambeth, and all the other cases that those cases cite. And these are distilled into these principles. The first is there actually aren't any special rules for interpreting planning conditions. They are interpreted similar to other public documents. And so secondly, the sort of overarching question is, what would a reasonable reader understand the words to mean when reading the condition in the context of the other conditions and of the planning permission as a whole? The third principle is that is an objective exercise. It is not a subjective exercise. It is not an exercise to be carried out by the local planning authority subject to, say, Wednesbury review by the court. It's an exercise that can be carried out by the court as a matter of law, having regard to the natural and ordinary meaning of the relevant words, the overall purpose of the permission, any other conditions which cast light on the purpose of the relevant words, and common sense. The fourth principle, it's not correct to say that there can never be a term implied into a condition, but courts must exercise great restraint in implying terms into public documents which have criminal sanctions. And obviously, when breach of condition may give rise to that, that's the context in which that arises. And the fifth principle is that the reasonable reader is to be treated as being equipped with some knowledge of planning law and practice. And that turned out to be quite important in DB symmetry, because what the court said was that there was a well-established practice of local planning authorities using Section 106 planning obligations to achieve what the claimants were seeking to achieve via the condition in DB symmetry. And they said because there was this well-established practice of using Section 106 obligations, it was much less likely the condition was intended to have the same effect. Looking then at Hillside essentially also states these principles as well. And what's slightly unusual is that DB symmetry doesn't actually refer to Hillside, even though it came a few weeks later. But there's nothing in particular to be gained around interpretation of planning permissions from Hillside that was novel. Obviously, Hillside was hugely important in relation to consistency between different planning permissions, but that's not what I'm going to be talking about today, as that's been done extensively in other forums. But what Hillside does make clear is that the meaning of a document can be determined in part on the basis of other documents to which it refers, such as application documents, plans and drawings submitted with the application, and reasonable reader of a permission can be expected to have regard to those documents, but not in relation to other materials, such as correspondence which passed between the parties, which might have some relevance in relation to some contract disputes. There is a body of law in relation to use of extrinsic material in that context, in private disputes. But when we're talking about a public document, when we're talking about a planning permission, those matters of private correspondence aren't ordinarily to be looked at in the interpretation of the planning permission. There was a recent case earlier this year, April, the Court of Appeal, in which two landmark barristers were on the successful side, which concerned live work lease covenant, that's AHGR Limited, and it was essentially about a residential unit. The individuals were a barrister and a doctor who were living in the development, but they weren't working there. And the question was whether or not that was in breach of a live work lease covenant. And the court ultimately interpreted that covenant to mean live and or work, not live and work, in the light of the planning permission which had been granted for the development. So the court had to look at what the planning permission itself said. And what was interesting is that there, the court said that the reasonable reader of the planning permission for the development would not have had regard to some of the extrinsic materials there, which included a relevant supplementary planning guidance document published by Southwark. It also wouldn't have included a superseded drawing which was submitted to the application, and it also wouldn't have included an earlier officer's report which was published prior to the grant of planning permission. The judgment doesn't go into great detail as to why the reasonable reader wouldn't have looked at those documents, but what's notable is the extent to which one can refer to extrinsic materials in interpreting a planning permission is not entirely well settled at the moment in the case law. I've also put here a reference to another case, Lazare Properties 2 Limited and Secretary of State, which concerned the Brunswick Centre in Camden and London. That was about the interpretation of reference to use classes, now that we have Class E under the use classes order, but it was looking at a condition that predated the introduction of Class E by about 17 years, something like that. It's quite a useful judgment to read for a sort of modern application of principles of interpretation, but it doesn't establish any great new principles. So turning then to section 73 of the Town and Country Planning Act, this is the provision that can be used to obtain a fresh planning permission for a development without compliance with conditions which previously had been imposed in relation to the same development. There's lots of case law on this. Much of the case law concerns the scope of section 73 and whether it can be used to change the development from something that it was in the previously. So this is about Finney and Welsh ministers, the case law concerning whether or not you can change the operative part of the planning permission or whether you can only use it to change conditions, and what is the distinction between those two. There's been a number of cases on that theme, which are item number 3 on this list that I've set out. So that's Reed, that's Armstrong, and that's Fisk. There's been a lot of activity in that area. I'm going to come to that at the end of this presentation. But before I get there, there's been a number of other cases concerning other aspects of section 73, which are not always in court. So the first one I'm going to talk about is interaction between section 73 and planning obligations. And the second is section 73 and commencement of development. So looking at planning obligations in section 106 agreements, it's now established that if permission is granted under section 73, and just as a reminder, section 73 amounts to a new grant of planning permission. It isn't, strictly speaking, an amendment of a previous planning permission. It's a new grant of planning permission. But if planning permission is granted under section 73, there is no assumption that any pre-existing section 106 obligation applies to that permission or to development carried out under that permission. That's to be left to the local planning authority to resolve in the grant of the section 73 permission, or it may have been dealt with in the original section 106 agreement. There may be a clause that applies it to further section 73 permissions. That derives from the Norfolk Homes case, which is about 3 years old now. In that case, the original planning permission had not been implemented, so the obligations in the section 106 agreement hadn't actually arisen in relation to the original planning permission. And so the new section 73 permission needed to be made expressly subject to the Section 106 agreement in order for the Section 106 agreement to bite when it was implemented, but it hadn't been, and so there was no planning obligation. In Redrow Homes, an applicant had submitted a Section 73 application to remove a condition that was no longer needed, but really the purpose of the Section 73 application wasn't really to remove that condition, but it was to seek to remove or vary an obligation contained in the Section 106 obligation to provide a footbridge for a housing development, because that the requirement to provide that footbridge was prohibiting occupation of 17 homes. And Mrs. Justice Levin distinguished Norfolk Homes in that case because she said, well, in this case, in Redrow Homes, the original permission has actually been implemented and actually has been completed. And so the planning obligation under Section 106 had actually been triggered already. And so the effect of a fresh Section 73 permission wouldn't wipe out obligations which had already arisen. But what's interesting is that Mrs. Justice Levin left open the question whether a Section 73 permission would remove an obligation which had arisen but had not yet become enforceable. And she sets out what she thinks might be the answer to that. And she says it's a matter for another case, but it is a material distinction between the two cases. Turning then to commencement of development in Section 73. Section 73 cannot be used if the original permission, which is subject to a time limitation, and that time limitation has expired without the development having begun. And Section 73 can't be used to extend that time period within which the development must be started. In the Atwill case, it was argued the Section 73 permission had been granted in respect of a development which had not been commenced within the time limitation. So it was argued that permission was unlawful. And Mr. Justice Lane held that argument was correct. The determination of the commencement of development under Section 73 should be the same as in other situations, such as relation to certificates of lawful use of development. In essence, the operations relied on to demonstrate commencement must be ones which, viewed objectively, can properly be said to be undertaken pursuant to the grant of the planning permission in question. It didn't depend on whether development authorised by the earlier permission could be implemented or built out. And in this case, Atwill, the earlier permission had not been lawfully implemented as construction had taken place in breach of planning control. And so the later Section 73 permission had the effect of unlawfully extending the time within which the original permission was to be commenced, and that was in breach of Section 73, 4 and 5. So turning finally then to restrictions on the use of Section 73 and the scope of what Section 73 can be used for. Until in the last year, the position on what Section 73 could be used for appeared to be fairly well settled following the Court of Appeal decision in Finney, and which essentially sort of put down what the principles are as the first major Court of Appeal authority on this point in some time. But in the past year, there have been 3 decisions concerned with this, and in 2, the High Court found that Section 73 had been used impermissibly to change the development itself rather than to change the conditions on the development. And in one case, the court did dismiss the challenge to its use and found that Section 73 had been used properly. I'm just going to focus on one of those 3 cases, which is Fisk, which is the most recent and was decided on 6th of September. But just to flag that all 3 cases are of equal authority and precedential value. And just because one High Court judge has found one thing, it doesn't necessarily mean that other High Court judges are bound to follow it. They are not so bound if they consider that it was wrong. But Fisk was a judicial review claim of a grant of permission under Section 73, varying conditions of a planning permission for solar farm. The original permission had included a 33 kV substation, and the effect of the Section 73 grant was to remove that substation. And the court held that this was impermissible. But Mr. Justice Morris went through the authorities in Section 73 in really quite great detail, setting out, going all the way back to PowerGen and previous cases like that. But he also looked at the 2 other cases from the last year. He looked at Reed and he looked at Armstrong. And he set out a divergence in case law concerned whether there is essentially one or more than one limitation on the use of Section 73. The claimant had submitted there were 2 possible limitations on the use of Section 73. One was that Section 73 permissions may not conflict with the operative part of the permission. And the second was that Section 73 permissions may not fundamentally alter the permission as a whole. Whereas the defendant said that there was only one restriction, and that was the second one, which is ultimately the question is, has the Section 73 permission fundamentally altered the permission as a whole? But the court found that both restrictions are applicable and are separate from each other. So restriction 1 is not limited to a case where the conflict or inconsistency with the operative wording is fundamental. It suffices that there is any conflict, and it encompasses the position where the condition alters the nature and extent of the grant, as found in the operative wording. So the fact that restriction 1 covers any conflict doesn't mean restriction 2 is nugatory, because restriction 2, if it exists, covers cases where there is no conflict with the operative wording itself. There is a difference in principle, therefore, between modifying a proposal before permission is granted by a condition imposed under Section 70 when the original permission is granted, which might cut down or alter permission, as long as that change is not fundamental. But there's a difference between that and changing a condition to an existing grant under Section 73. Now, I think this is unlikely to be the last word on the subject, but it is at the moment probably the clearest distillation of the different principles and how this applies going forward. But I think remains to be seen where the case law will go in the next year or two on this. So that concludes my presentation.
Charles, thank you very much. The next speaker on the topic of heritage case law is Rupert Warren KC, who needs no introduction. He's former head of chambers at Landmark, head of our planning steering group at the moment, and is a well-known leading practitioner both at inquiry, particularly in residential matters, and before the courts. Rupert.
Well, good morning, all. I have a series of cases for you from, broadly speaking, the last 12 months. It's been a fertile ground as ever, heritage for judicial review challenges, statutory challenges to appeal decisions, despite all the best efforts of the Court of Appeal and other judges in the past couple of years to restrict these matters to planning judgment as much as possible. It's a complicated area because of the overlap between case law, statute, and all of the judgments involved in the MPPF. So what I've got for you this year is not so much large cases determining huge points of law about the meaning of the Act or the MPPF, but a series of interesting, more detailed examples of how the courts are dealing with that plethora of challenges. That, some of you may well know, is the fine former Debenhams in the High Street of Staines upon Thames. And in that case, the claimant applied to demolish and redevelop the building. Debenhams having closed, as you'll be aware, for residential use. The building was unlisted and it wasn't in the conservation area. It also applied, unsurprisingly, for prior approval to demolish, to ask whether it needed prior approval, and was told it did need prior approval to demolish the building. What then happened was the authority, defendant in the judicial review, consulted on extending the conservation area to include the building and its immediate surroundings. And it did so based on a report from an expert which it hired, which placed considerable weight on the value of the building itself, rather, the court found, than the area in which the building sat. Now, the claimant instructed an expert whose report was inadvertently, it appears, left out of consideration when the conservation area extension decision was taken in June of last year. By that time, permission had been refused for the application, and the claimant had served its notifications, you have to, of appeal by inquiry. And then, having seen the extension of the conservation area affecting, obviously, the building, it served pre-action protocol letter in a judicial review relating to the 29th of June decision. So this is a case challenging the extension of a conservation area, which on the face of it looked like a reaction to an application to redevelop a building which wasn't at the time in the conservation area. Now, having received the pre-action protocol letter, the defendant wrote a supplementary report, or received a supplementary report in which the claimant's expert views were taken into account this time and assessed. And having considered that report, the decision to make the conservation area extend to include the Debenhams building was endorsed. Now, in the case, the claimant argued two main things. Firstly, that the material consideration had been omitted from the main decision in May to extend the conservation area, namely the expert report, which also referred in some detail to what Historic England has said about the listability of the Debenhams store. And they also argued that the error wasn't saved by the supplementary report, which the authority had commissioned, because that was unlawful anyway. It was unclear, it was said, whether it amended or entirely replaced the original report, and it was a classic example of ex post facto after the event reasoning anyway. The defendant, on the contrary, said there wasn't an error which should lead to quashing, because the supplementary report in effect had cured the problem. It showed that the same result would have been obtained anyway, and it was thorough and detailed. It was said by the authority, clearly dealt with what in the end was a matter of planning judgment, a difference in expert opinion. And they argued that section 31(2)(a) of the SCA, with which many of you will be familiar, applied, because the result would almost certainly be the same, would have made a difference anyway. The judge quashed the decision to extend, that should say, the conservation area, holding that the claimant's expert report was a material consideration, something which I think was largely accepted within the argument. Judge also found the supplementary report didn't rescue the defendant. It was ex post facto reasoning, and it didn't, the judge found, on a fair reading, grapple with the points in the claimant's representations. What it done instead was dismiss them in a defensive way, the judge found, while doing an about turn on the key focus of the decision, which was the special character of the area rather than the merits of the building itself. And so 31(2)(a) was found not to apply because the decision they went have been different. Taking away from that, statutory duty, important point, often ignored, to keep the conservation boundary under review is an ongoing decision. So because of section 69(1) of the Listed Buildings and Conservation Areas Act. And so the judge stressed the case was different from one where the authority was functus officio, where it had discharged its functions in relation to that decision. And the defendant could, probably, should have rescinded the decision to extend the conservation area to include the building and just restarted the process, taking all of the relevant points into account. But instead, what it did was take a defensive position, sort of paper over the problem caused by the original failing. Sometimes it's better to admit the mistake and start again. That mistake was compounded because what the supplementary report showed was the underlying problem. The conservation extension was based on the lack of a proper focus on whether there was a suitable area to designate, and was almost entirely focused on the building which was under threat. So even though this was a case where the court stopped short of putting it in the same category as those cases like the Arndale and Worcester case, where it was manifestly a strategy to prevent the demolition of the building, it nonetheless found it was tantamount to that kind of problem. That is St Anne's Church in Newcastle, or Newcastle. The appellant developer sought to overturn a decision which had been taken by Mr. Justice Holgate in the High Court. He had quashed an inspector's decision granting permission for two blocks, and broadly speaking, from most important views, in front of the church, 11 and 14 stories in height, and they impacted the church's setting. Everyone agreed it's a Grade 1 listed building. There was a long history of regeneration policy and guidance affecting the regeneration site. The defendant, the City Council, long wished to see it redeveloped. And the inspector accepted that any development on the site would cause harm. Any development would cause harm to the setting of the church because the site lies in front of and below the church. And in particular, the inspector found, to quote them, there could not be a vastly different design response which could further minimise the harm to the Grade 1 listed building. So harm in any event, whatever design was chosen, to paraphrase it. And the inspector also found that given the key constraints of the plot, those became important words, and the nature of the harm identified, this is towards the lower end of any scale, it's less than substantial harm. So in the challenge, the appellant developer argued, so this is seeking to overturn the quashing by the High Court in the Court of Appeal, They argued the inspector hadn't heard because she used the expression "given the key constraints of the plot" as a means of referring back to her assessment of the setting of the listed building, rather than as part of her reasoning on the degree of harm, but not part of the degree of harm, but a more contextual point. Having won in the High Court, the defendant counsel resubmitted its case that it was clear that the inspector had fallen into error, because when she used the words "given the key constraints of the plot," she was in fact taking into account her finding that any development would cause harm as a constituent part of her finding on the degree of less than substantial harm. So she'd rolled in this general point into the principal question, which was what was the degree of harm. And in the alternative, the defendant said, you couldn't tell. The Court of Appeal upheld Mr. Justice Holgate, upheld the quashing of the decision for slightly different reasons. Importantly, this is a takeaway point, there was no doubt that if the inspector had taken into account her finding that the constraints of the site would mean that any scheme would cause harm as part of her finding of the degree of harm, that would have been a mistake. So this general point shouldn't be rolled into the primary consideration. But the court wasn't prepared to go quite as far as Mr. Justice Holgate, and just found that the sentence was so ambiguous you couldn't tell what the inspector had done. And so the decision should be quashed. And that's what the other two members of the Court of Appeal also found, citing, in fact, the fact that Sir Keith Lindblom and David Holgate have both found it difficult to understand as it were conclusive. There was sufficient doubt about the meaning of the sentence that the decision should be quashed. So, as I say, the first point is just remember that alternative schemes are not likely to be relevant to the principal question of impact of harm. What degree of harm does the scheme itself cause? The case also serves as a cautionary tale about decision making, because it was a relevant planning consideration that the site in question was a development site which everyone wanted to be developed, and that it was unlikely to be developed in a way that would cause less harm. It was just that the planning consideration came in the wrong place in the reasoning and shouldn't have infected or been muddled up with the main finding on degree of harm, should have been elsewhere. Jumping back just to touch very briefly one just before the 12-month period, the Holocaust Memorial, you'll see just beyond the proposal itself, the Buxton Memorial, just to the right of the Victoria Tower in that shot. And you'll remember the Secretary of State applied for permission to develop a Holocaust Memorial. The application was granted by the Housing Minister. And the inspector, without anything further being said by the minister, found that the impact of the development on the Buxton Memorial and the garden, the RPG, didn't approach the level of substantial harm within the meaning of the framework. And they referred in doing so to the Bedford case, with which you'll be very familiar now, sometime old. And the trust, as well as other grounds, and one of which succeeded, of course, challenged the decision in part on the basis that the minister had used the wrong approach and the wrong definition of substantial harm. What the judge found was that the inspector and the minister, on a fair reading of their documents, hadn't used the words, hadn't relied on the words in Bedford, which speaks of substantial harm meaning the draining away of significance, constituting substantial harm. But the inspector had engaged in his own careful, even poetic, it was said, assessment of the ideal of substantial harm. But the judge commented further, it is obituary, I think, but commented further about Bedford, and this is an important point, I think, that the judge in the Bedford case, Mr. Justice Jay, wasn't intending, she found, to gloss the NPPF, and wasn't saying that the test for substantial harm was based on the idea of the significance draining away. Now, that section, I think, is probably the most important one to come from the judgment for wider use. It provides a later kind of corrective view to the widely held assumption, certainly practice, that when you're thinking about substantial harm, it means draining away of all significance of the asset. But you've got to look much more closely, I think, in the light of that, at the PPG definition of substantial harm, which is potentially a serious effect of one key aspect of the significance of the asset. And that has an effect also on where the top of less than substantial harm is, and therefore what's moderate substantial harm, less than substantial harm, etc. So it's, despite the scope given by the Court of in Bramshill, this is a case which does provide a little bit more corrective guidance on these troublesome categories in the framework: less than substantial and substantial. That should say Widdington, forgive me. That's Widdington Conservation Area in part, just south of Saffron-Walden in Essex. And this was a case decided, I think, by our own Dan Kalinsky KC, sitting as a deputy judge. And it was a case about a site which lay very largely, not entirely, but very largely outside a conservation area. And there was no 5-year housing land supply. So even though it was in the setting of the conservation area and some listed buildings, the authority granted permission, and it did so based on an officer's report which said the site was outside the conservation area. Secondly, it said there'd be no harm to the setting of assets, but at the same time, it also said, unfortunately, the report, there would be a low level of less than substantial harm. And thirdly, it said that 11D, the presumption that's engaged by the lack of 5-year supply, was engaged and the presumption applied. It was challenged by objectors. Firstly, the decision, they said, was vitiated by a material error of law, of fact, the fact that members had wrongly advised that the site lay entirely outside the conservation area. Secondly, they erred when considering the degree of harm that the scheme would cause because the report was internally inconsistent. So it said both harm and no harm. And finally, the members were seriously misled because they never got to the balancing exercise under 202 because they were told that there was no harm. Now, the decision was quashed. Interestingly, though, the judge rejected the first ground, the error of fact ground, because looking at the case law, he felt that it just didn't matter, it was just too small a point. But the internal inconsistency and the fact that there had never been a chance for the members to actually exercise their judgment about public benefits versus degree of harm brought the decision down. So not every slip will result in a quashing. The PPG guidance is that decision makers should clearly set out where on the spectrum of less than substantial harm and impact is judged to lie. And that guidance should be corrective of the kind of error that occurred, it seems to me, in this case, where the proposal was both, just a mistake. And getting that less than substantial harm degree right is critical because, of course, it then engages or doesn't engage paragraph 202 and the rest of the. So more than technical errors, despite the fact that by the look of it, the chances of any harm being sufficient to actually outweigh the benefits in that case might have been slim. 2 pictures. One is an abandoned area, which it was alleged had been allowed to fall into disrepair. And the other's a milk shed, only joking. On the right, we have the conservation area in Christchurch in Dorset. 2 cases, just wrap up into one for you quickly. The proposal in Simmons was for 13 dwellings, that's the milking shed case. And the proposal also involved having to demolish that somewhat dilapidated milking shed, and that was curtilage listed, so that's where we get into the heritage topic. The claimant had, again as an objector, suggested that it was in such a bad condition because the owner had let it deliberately deteriorate, and therefore paragraph 196 of the framework was engaged. That's where you must disregard how bad it is because it's been deliberately left to rot. And the allegation and that point about 196 hadn't been considered by the committee in granting permission. And so there wasn't any reference to the right balance. And in the other one, the conservation area in Christchurch, a neighbour objected to the extension of a bungalow, and the conservation area officer's response said there might be damage caused to the setting of the asset, but their response wasn't put in front of members other than a summary, which referred to wanting revisions, not an actual summary of the suggestion by the officer or judgment by the officer about what the degree of harm would be. In the first one, the judge rejected the allegation that the members had been seriously misled. Of course, that's the general test, Maunsell, about the weight to be given to any harm because they hadn't been told to give considerable importance of weight. So that was the allegation. That label wasn't used, that formula wasn't used. Judge rejected the fact that that hadn't been used as a mistake. And the decision was quashed because the committee had simply failed to assess, however bad the point was, the 196, paragraph 196 point about deliberate neglect. And in the Flaherty case, the Christchurch case, the challenge was dismissed. The judge just said they didn't think the allegation that a failure to repeat the conservation area officer's views was material, and it was up to the officer who was recommending to form a different view. It's an interesting point when you see it in general. So quickly, the takeaways from those: courts less and less interested in arguments about labels, considerable importance of it being trotted out in decisions. But all the points, however bad they are, should be put before the decision maker. And there, Simmons is a good example of a bad point which still managed to bring the permission down because it was mishandled. And in Simmons, the point about the absence of reference to the weighted balance is interesting. It failed in that case, but experience shows the point is very often misunderstood, mishandled, and that case could have ended differently. So just by way of a parting shot, looking forward, many of you will be aware of the Marks and Spencer's Marble Arch decision, first of all, which has been challenged. One of the most important cases on heritage in the year ahead, because it talks about optimization, design, and the relationship between heritage and carbon, which I think is an evolving, hugely important subject. Still difficulties with less than substantial and substantial, as these cases show, circling around misapplications and misunderstandings. And you'll notice that in the LURA, that statutory protection for SAMs, REC sites, RPGs, and World Heritage Sites settings have come in, but not conservation areas. I say come in, they will come in when and if they're commenced under section 102, but it's a broadening of the protection of settings in statute rather than just in policy. Quick canter for you of the year and what's ahead, David.
Thank you very much, Rupert. And our final paper is a joint production from Richard Turney and Natasha Jackson. Richard is a senior junior and experienced in planning and environmental litigation, both at inquiry and before the courts. Natasha has primarily a public law practice, but is closely involved with advisory work on retained EU law and the wider implications of Brexit, and is currently acting in litigation in the Court of Appeal in a series of cases concerned with the implications of the withdrawal agreement. Richard and Natasha, over to you. Thank you.
Thanks, David. And I think I'm kicking off with our topic, which is retained EU law in planning and environment cases. And Rich and I are going to be talking to you about the new Rule Act, the Retained EU Law Revocation and Reform Act 2023, and some of its implications for planning and environment law. I'm going to start us off by giving a bit of an overview of the new Act and its controversial journey through Parliament, and Richard is then going to talk about how we anticipate that these changes might play out in practice. The Rule Act, as many of you will be aware, is legislation designed to replace and reform EU-based laws in the UK following Brexit, and it will come into force on the 1st of January 2024. The starting point to understanding the provisions of the new Act is the concept of retained EU law or rule. When the UK left the EU, the policy decision was taken to preserve the legal status quo at the end of the Brexit transition period, i.e. the 31st of December 2020, with the intention of ensuring that UK law remained consistent and coherent after Brexit. Any other approach would, of course, have resulted in huge gaps appearing in the UK legal system overnight. So the first question is, what is rule? And you can see from the slide there that rule is a relatively new concept in domestic law, introduced by the EU Withdrawal Act 2018 as amended by the EU Withdrawal Agreement Act 2020. The 2018 Act provided for the post-withdrawal transition period. The 2020 Act amended those provisions to ensure that at the end of the transition, domestic law continued to operate as it had done. The 2018 Act made provisions at Section 2 for existing domestic legislation which implements EU law obligations to continue to have effect. And it terms this EU-derived domestic legislation, or EUD. Section 3 provided for the continuing effect of direct EU legislation, which includes EU regulations, decisions directed at the UK, and EU tertiary legislation. And Section 4 contains saving provisions for any rights, powers, liabilities, obligations, restrictions, remedies, and procedures that are of a kind recognised by the CJEU or any court or tribunal in the UK before exit day. It is important to note, however, that the continued effect of EU treaties and directives, which are not direct EU legislation, depends upon whether the CJEU or UK courts have recognised the kind of provisions in question prior to 11 p.m. on the 31st of January 2021. As you can see from the slide there, the 2018 Act defines these three categories. So that's EU-derived domestic legislation, direct EU legislation, and anything that is retained EU law by virtue of Section 4 as rule, REUL, retained EU law for the purposes of the Act, and that's provided for at Section 6.8 of the Act. So can I go to the next slide, please, Laura? So the question then becomes, what was the effect of rule under the 2018 Act? As I said a minute ago, the main policy objective behind the 2018 Act was to preserve the status quo. And the complexity here was that simply keeping EU law on the statute books was not going to be enough. The operation of the domestic legal system in alignment with the EU regime depended also on an alignment with union precedents and with the application of interpretive approaches and principles. And as Richard will go on to talk about, these interpretive tools and general principles of EU law are particularly relevant to planning and environmental law, where, for example, the EU-derived precautionary principle significantly underpins decision-making without necessarily appearing on the face of the relevant legislation. These complexities were, broadly speaking, accounted for in the 2018 Act. Section 6.3 set out how questions relating to the validity, meaning, or effect of any retained EU law are to be decided, and provided that they would be answered first in accordance with any retained case law and any retained general principles of EU law, and secondly, having regard, among other things, to the limits before Brexit of EU competences. Further, the 2018 Act provided that the interpretive obligation applied even if the retained EU law in question had been modified, so long as doing so is consistent with the intention of the modifications. And that's at Section 6.6. So in short, the approach to defining and retaining rule in the immediate aftermath of Brexit was to preserve it wholesale, with an understanding that it would then be open to the government to decide on changes to the retained law over time with full scrutiny and proper debate. And that full scrutiny and proper debate quote is from the command paper that was published in March 2017. So can I go to the next slide, please, Sarah? Clara? Great. So that slow and steady approach all changed with the appointment of Jacob Rees-Mogg as business secretary in summer 2022. And at that point, the policy objective shifted towards instead dramatically removing all EU law from the books. And the rule bill that was originally presented in Parliament in autumn 2022 contained a number of significant measures to axe rule from the domestic legal system, the most controversial of which were the sunsetting provisions. And if those provisions of the bill had passed, the sunsetting provisions would have had the effect of sunsetting all EU-derived subordinate legislation and retained direct EU legislation at the end of 2023. That could be extended until 2026, unless that law had been actively specified for preservation in regulations made by a relevant national authority. Now, this somewhat understandably set hairs running because the sunset would have essentially meant that all laws concerning EU obligations could have disappeared from UK law at the end of this year, so in about a month and a half's time, unless specifically preserved. And Richard and I, along with some other members of Chambers, were involved in advising various government departments on really quite knotty questions about the scope and implications of the sunset clause and the risks of unintended consequences. And it is perhaps unsurprising that the strong opposition to this aspect of the bill from the Lords and from civil society more widely led to those provisions being cut. And that was announced by Kemi Badenoch as minister responsible for the bill in May of this year. So instead, what we have now in the current Act is a detailed sunset schedule, which is at Schedule 1 of the Act, which specifically identifies around 500, well, not around, it identifies 587 pieces of rule that will be sunsetted at the end of this year. And I think we can comfortably say, at least for our purposes in this talk, that the schedule contains virtually nothing of any importance. And I think that quote, virtually nothing of any importance, was actually used by the Lords in passing to reflect their general take on what was actually still included in the sunset schedule. So broadly, the sunset is no longer the case. Next slide, please, Sarah. So that takes us to the Act, the Retained EU Law Revocation and Reform Act. I think it's fair to say that the Act that has in fact been passed into law is a significantly wounded version of the bill first presented to Parliament. But that said, it does still make a number of very significant changes to the continued operation of EU law and principles in the UK, and that we expect will have notable implications for planning and environment lawyers. Obviously, the new Act is a relatively complex new instrument, and there's a lot that could be said about it in more time than I have, but I'm going to pick out some of the key provisions as they relate to the field of this talk. So firstly, you can see in the bullet point list there, renaming rule. The first change to note is that the new Act renames two categories of rule, that is directly applicable EU legislation and EU-derived domestic law, as assimilated law from the 1st of January 2024, and that's provided for at Section 5 of the Act. The Act also turns the rules of supremacy on their head, and that's the second bullet point there. Section 3 provides that the supremacy of rule in UK law will be abolished at the end of 2023, such that retained direct rule will no longer take priority over domestic law, meaning non-EU-derived domestic law, and that domestic law will not have to be read to give effect to retained direct rule. So there will instead be a new rule of priority, which will result in direct rule being interpreted as far as possible to be compatible with domestic law, and domestic law taking priority in the event of conflict. So as I say, that's kind of turned the rules on their head. The third bullet point down is ministerial powers. The Act, sections 11 to 16, contains broad powers permitting ministers to make substantial restatements, revocations, and replacements of secondary rule, or it will then be called secondary assimilated law. And these powers will provide ministers with substantial discretion to make legislative changes with these powers, most of which can be exercised with limited or no parliamentary scrutiny. So that's quite a big change in this new Act. The fourth bullet point there is a repeal of directly effective EU rights and obligations. This is of potentially great significance to planning and environmental laws in particular. And it's a provision at Section 2 to repeal directly effective EU rights and obligations, which will mean those rights, powers, obligations, and liabilities contained in the EU treaties themselves and in directives that weren't successfully implemented. Those obligations will all fall away. And I think Richard might be talking a bit more about what implications that change will have in this field. Then we have abolition of general principles of EU law. This is also of significant note, and it comes at Section 4 of the Act. And the provision is at Section 4 is that the general principles of EU law will fall away at the end of 2023. So a few things to note. First, there is no list of general principles. These are defined in the new Act by reference to Section 6.7 of the 2018 Act. You end up then with a bit of a kind of follow the arrows game, but broadly speaking, the term does include principles that have been recognised as such by the CJEU. And again, Richard will talk a bit more about how that translates to this field. But the other point to note here is that there is no power in the Act for ministers to preserve these principles in themselves. So a fair amount of thought needs to be given as to how this change will play out in practice and how those principles that might want preserving might maybe preserved going forwards. We then have second to bottom on the list, changes to precedent and the application of case law. So this is the final aspect of the Act that I'll draw attention to, and it's the role of the courts under Section 6 of the new Act. The Act makes an unsurprising yet significant change in providing that the Court of Appeal and the Supreme Court will first no longer be bound by retained EU case law unless it has already been modified or applied in binding domestic case law. And secondly, will be permitted to depart from retained EU case law to bring in domestic case law that has been influenced by retained EU case law. The Act does require that the courts can only make such departures where thought has been given to the extent to which retained EU case law restricts the proper development of domestic law, and the extent to which the domestic law was influenced by retained EU case law to begin with before deciding not to follow it. But these provisions still provide a substantial and permissive authority to the courts, and we'll have to keep a close eye on how the courts choose to use these new powers to align or depart with existing EU authority. My final point before handing over to Richard to discuss how these changes might play out in practice is to just draw your attention to the reporting requirements that the Act places in Section 17 on the Secretary of State to report on the progress of revoking and reforming rule. And these requirements operate in respect of the period until 23rd of December this year, and then every 6 months until the 23rd of June 2026. The Minister must also update what is referred to as the rule dashboard, which is an online catalogue of legislation identified to be rule that was set up, I think, around the time that the bill was first proposed, and must also summarise the data on the dashboard as part of this reporting. So we should, theoretically at least, be able to keep track of the progression of rule and continue to consider its developing implications through monitoring this reporting. So thanks very much. That's all from me. I will hand over to Richard.
Thank you, Richard.
Good morning, everyone. Hopefully you can hear and see me. I think the next sort of step in the discussion is moving on to talk about the practical application of the Act when it comes to planning law in particular. And obviously the two main areas, and not the only areas, but the two main areas where we come across this retained EU law, as we now have to call it, is in respect of habitats protection and environmental assessment, so EIA and SEA. I think, as Natasha has identified, that the provisions make clear that there are material changes to the way the law operates. The key difference between the Act as enacted and the bill that we thought we were going to face is that effectively the implementing regulations that we're concerned with are going to remain on the statute book unless and until amended. And obviously there are proposals for amendment on both counts. In terms of supremacy then and the general principles of EU law, I think the important points to note are that there will be a material change in the legal framework, with the effect that some of these principles no longer have the status that they had before. And I'm going to talk in particular about the precautionary principle and how that might affect determinations under the Habitats Directive or Habitats Regulations and under the EIA and SEA regulations. The real problem, which I'll explain, is untangling all of the various ways in which we get to our current understanding as to the effect of habitats law and environmental assessment law. Sorry, I should have said at the outset, my slides have not appeared, which is inadvertent and my fault, but they'll certainly come through when you get the pack at the end. In terms of first then habitats, you've already heard about the Fry case and the relevance of the Fry case to our current understanding of habitats law, and of course the particularly controversial area of nutrient neutrality. I think it's worth looking forward to the Act and to the law in 2024, pointing out that parts of the reasoning in Fry depend on the precautionary principle, and the precautionary principle as a general principle of EU law will no longer, through the vestige of EU law, continue to have effect. However, I think it's fair to say, or certainly in my assessment, that's really not going to make much of a difference to how cases like Fry are decided, and I'll say that for a few reasons. One of them is the particular way in which the habitats regulations are framed, and you may have seen the discussion around Regulation 9 of the habitats regulations, which includes a duty to give effect to the principles in the directives. That at present remains unchanged, and therefore the precautionary principle as an element of the directives remains the same. The second point is that regardless of whether you can still say that the precautionary principle is a starting point for interpretation of the regulations, there is a whole body of case law which continues to have effect unless and until that case law is revisited by the appellate courts in England and Wales. And that means that as things stand at the moment, the principles articulated in CG Fry for dismissing the claim are the same, at least at High Court level, with or without the precautionary principle as a general principle of EU law, effectively binding authority at Court of Appeal and higher level in the UK, but also that line of community case law that's relied on. So simply removing the precautionary principle from the set of tools that are used to interpret the habitats regulations is not in itself going to lead to a different answer, or not necessarily lead to a different answer. I think the further point to make is, of course, the precautionary principle in FRI is part of the mix. It's not the whole answer to the question. So part of the point in FRI is that the multi-stage consent process is recognised in community law. Well, that's true, but that's not just because of the application of the precautionary principle, i.e. don't leave the impact unassessed, but also an aspect of the proportionality principle, that you should do an appropriate level of assessment for the stage that you're at. So that's effectively a principle that is in favour of the assessing authority, in favour of the developer, if you like, and it is a principle that means that you don't have to carry out a full assessment when some effects cannot be known at that stage, but where those effects will be controlled at a later stage. So I think in summary, my conclusion is that on cases like FRI, there won't be a sudden change in how those cases are reasoned or decided through removing the general principles of EU law. That will require a clear departure from an extensive line of authorities about how those principles work in practice. I think there are examples of cases which may be decided differently if they were re-argued next year. Harris and the Environment Agency is an interesting case about the application of the Habitats Directive in respect of the review of water abstraction licenses. And that is a case which really is a principle of direct effect about Article 6.2 of the Habitats Directive and how that should take direct effect in respect of decision making by the Environment Agency in its water abstraction duties. Harris, I think, potentially could have been differently decided if it was being decided next year in relation to this act, but that's because its determination is about applying the directive principles directly rather than about looking at the proper meaning of the implementing domestic legislation. And of course, that is now to be saved. In respect of environmental assessment, the position is perhaps a little less stark in that the assessment principles in the EIA and SEA directive that feed through into the domestic implementing regulations don't turn in themselves on any issue of general principles of EU law, although it is clear that the existence of a precautionary approach has informed a large number of the cases decided, particularly at CJEU level. And it's worth pointing out that some of the recent domestic litigation, so Finch and then the Greenpeace and Uplift case on EIA and SEA respectively, in respect of downstream emissions from oil and gas extraction plans and planning permissions. In both those cases, the claimants argued for a precautionary approach which would broaden the scope of the assessment to include downstream emissions. And obviously their basis for doing so was the existence of that general principle of EU law, which in light of the provisions of the Rule Act will no longer be an argument that's open, at least in that straightforward way, next year. So potentially there's some shifting sands. However, I think my overall assessment of the effect of the provisions for planning law in particular is that this is no longer going to be a seismic change. And I think I would identify the following reasons for meaning that the Rule Act is no longer going to make a seismic change to the way in which planning matters are handled both on a day-to-day basis and in the courts. The first point is, of course, that the law as it stands is being preserved. The sunset is disappearing or has disappeared, and that means that the body of domestic implementing regulations will stay on the statute book until they are revisited. And obviously We know the government's proposals in respect of environmental outcome reports. There's ongoing debate about whether the habitats regulations need to be rewritten. Those debates doubtless will go on over the next couple of years, but in the meantime, the regulations will remain the same. The second point is that the case law continues to influence unless and until the domestic courts take a different view. And I think really the point is that the body of CJEU case law, which informs our understanding of the habitats regulations and indeed the process of environmental assessment, is so well established that you would no longer say that it's controversial, and it has been reflected repeatedly in domestic decision making up to the highest level at the Supreme Court. So there is a lot of material that the domestic courts would have to overturn before they could come to the conclusion that suddenly the habitats regs or the EIA regs are to operate in a different way from how they've been understood to date. The third point I'd make is that, of course, these principles have pointed towards a purposive approach to interpretation of the domestic regulations to reflect those general principles of EU law. But a purposive approach to interpretation is not in itself confined to EU legislation. The courts take a purposive approach to interpretation in many interpretation disputes in respect of legislation. And that means that it will still be legitimate to say, what is this particular regulation seeking to achieve and how should it be understood in that context? And there's no doubt at all that the habitats regulations are intended to take a precautionary approach, and you get that from the language of the regulations, even if you don't necessarily get the full gamut of arguments that has been accepted by the CJEU in terms of how far you go with the precautionary approach. We know there's a precautionary approach bedded in to the habitats regulations. It's clear from its language, for example, the requirement for prior assessment and the prohibition on the grant of consent unless that assessment has come back with an appropriate answer. And part of the tools of interpretation here are going to be the wider context as well. And one of the interesting features of this argument about the precautionary approach and how it informs interpretation is that whilst Parliament has been removing that general principle of EU law from our collective legal conscience, it has at the same time given effect to the Environment Act 2021 and the Statement of Environmental Principles. Those have been set out. Section 17 of that Act sets out the key principles, which include a precautionary approach to environmental law, and the government has given its statutory statement as to how those principles will be applied. And again, that includes a precautionary approach. So the idea that removing the application of the precautionary principle as an example of a general principle of EU law would suddenly change the way in which we understand these legislative provisions, I think is wrong. I think the precautionary principle clearly remains part of our understanding of how environmental law should work. It is reflected in a line of case law, and it can be derived also from the language of the relevant instruments which remain part of domestic law. So taking those two areas and the key areas for planning, whilst there is, I think, a distinct possibility of movement away from some of the CJEU case law, I don't think it's possible to say that there's going to be any kind of seismic change coming next year in the way we understand habitats or environmental assessment law. But there's clearly room for argument, and it will be a fresh line of argument that can be pursued in the relevant cases. So as I say, my slides on this will follow. Apologies for not putting them up, but I'll hand back to David to conclude.
Richard, thank you very much. We've had a large number of questions, and I will pick a few out and see how many we can get through in the time available. Charles, I think since we've had a large number of questions about Section 73 and your talk, I think we'll kick off with you. Can you deal with Siddhartha's questions about Section 73 and the variation of conditions and the limit on the scope of the Section 106 obligation in a Section 73 application?
Yes, thank you, David. So we've had a question which is about when you make a Section 73 application, what is the scope of what can be done on a Section 106 obligation in respect of the principal permission? So the original, I think I take that to mean the first planning permission that was granted under Section 70. I think the answer is that it's a bit complicated. Norfolk Homes and the Redrow Homes case from this year, which Mrs. Justice Levin handed down, do look at this question. But I think the sort of principal point to make is that generally the second Section 73 application is not intended to amend or do anything in relation to the Section 106 planning obligation. In Redrow Homes, the original planning permission had actually been implemented, and so the Section 106 obligation had been triggered. The obligations were there as a matter of private law. So the Section 73 permission couldn't do anything in relation to those previous planning obligations. In order to do something about those, that had to be done within the scope of Section 106 and within the scope of the agreement that had been reached between the parties. What Mrs. Justice Levin leaves open is whether a Section 73 permission could remove an obligation which had arisen but had not yet become enforceable. So that is about a slightly different situation. So that's about where you might have implemented, but for some reason Section 106 hasn't yet been triggered because of the terms of the Section 106 agreement. PowerGen says you can elect whether to implement a Section 73 consent or an original consent. But where you've actually already implemented the original consent, what Mrs. Justice Levin says is she thinks it's unlikely you could use Section 73 to change the effect of the Section 106 obligation. So I think reality is you shouldn't be looking to use Section 73 to change a planning obligation. That's not really what it's for. There might be some ways in which you can do it, but it seems unlikely at the moment. I'm not 100% sure that does address exactly what Siddhartha was getting at, but I think that is somewhere close anyway.
I think that must be right. I mean, the difficulty arises if you've already implemented and triggered the application of your Section 106 agreement, because you're then stuck in the territory of having to go down the route of Section 106A. If you look at the Hitchens case, which is one I mentioned in my initial response, that was a case where they hadn't implemented, and the Court of Appeals said, well, you can choose which one you implement. But of course, if you've already exercised that choice and implemented the original permission and triggered the conditions in the 106, then you're stuck with it, subject to agreeing a variation.
Yeah.
Thank you. Joel, there's a question about CG Fry. Well, there are two questions. Firstly, can it be extended to caravan site licensing? And then secondly, do you consider that a fresh appropriate assessment ought to be secured at a later stage, even if it's already been produced earlier at an outline stage where, for example, there are material changes?
Okay, so I'll take the first one about the extension to something like a caravan site license. I think effectively what Regulation 63 requires is a two-stage assessment process. So first off, you've got to have a screening stage. So that's an assessment by the competent authority as to whether a project or plan is likely to have a significant effect. That's that really low screening threshold. Now, if you overcome that, then the competent authority must carry out an appropriate assessment. So if the plan or project you're talking about fits that, whether it's for a caravan site or anything else, then you have to carry out that appropriate assessment. So that's what I'd say on the first question. And then on the second, regarding CG Fry, the question is, do you consider that fresh A ought to be secured at a later stage, even if one's already been produced in light of a material change? Well, I think just to be clear, what CG Fry makes clear is that an appropriate assessment can apply at the reserved matters or discharge of condition stage, even where there's been a grant of outline planning permission, where the subsequent approval was the implementing decision. And I think the point that was made by David following my talk is effectively that once a project receives a positive screening, Article 6.3 requires that the competent authority should not agree a project until that assessment's been undertaken, and it shows that it's not going to adversely affect the integrity of the site. Now, that a planning consent is part of that agreement, and that, to use the language of Article 6.3, when it's necessary to implement a development. So if you've in CG Fry, they actually hadn't done the appropriate assessment at the point at which it was being considered the condition stage. But in respect to the question, you're saying, well, we've already done one, but something's changed. And it seems to me that if you've got another consent stage coming up, then the competent authority, and there's been a material change, and you've passed that screening threshold, then you're going to have to do another appropriate assessment, taking into account everything.
Joel, I agree with that. I had the unfortunate task of arguing in front of the European Court of Justice, the Barker series of cases about EIA and subsequent consents in planning, and it's quite useful. I mean, the parallels are not completely exact, but they're pretty close, and it's quite useful looking at Lord Hope's speech in Barker and Bromley when it got back to the old House of Lords, as to precisely the circumstances in which you may need to do a subsequent approval EIA. And the same, I think, applies to appropriate assessment, either if you've not done it at all and it suddenly becomes clear you need it, or, as you said, if there's a material change in circumstances. I mean, if you're unlucky, you might find the new site is designated or new data becomes available, or there are other circumstances which arise which simply weren't known at the time. So I think that's right. But Lord Hope, I think, is quite useful in Barker.
And I think with that, I mean, CG Fry is really interesting there, where it says about scope, I think, following on from that, David, that you're not just assessing simply what the impact is of just that condition, but if this is the final stage in the implementation of this project, then if you're conducting a subsequent assessment, you're going to have to assess everything, as in the impact of the entire project. And that's made clear there by the court.
Question to throw out to Richard and Natasha. Where do we end up in terms of EU principles, the precautionary principle, all those matters, post alteration to the environmental assessment and HRA processes following the implementation of LURA? Sorry, I keep.
Shall I go first? I think it's obviously we're going to have a change there in terms of assessment, and I think we've got to talk in the next part of this series about the environmental outcomes report process and how that is proposed to replace SEA and EIA. I think one of the key things, though, about precautionary principle in that context is that the government has now effectively bound itself to give effect to the precautionary principle in its policies. And we see that in the Environment Act 2021 and the Statement of Principles that was issued a month or so ago, I think it was. So I don't see there as likely to be a sort of change driven by removal of the general principles of EU law. I think the change is a change of approach. I think we will see when the detailed provisions come out on environmental outcomes. I think we will almost certainly see reference to the precautionary principle as a matter of policy, reflecting Section 17 of the Environment Act and reflecting the Statement of Principles that's been issued. So my overall view, as you would have got from my brief talk, that I just don't think this is going to be the sort of seismic change that some people fear or maybe wanted. I think we're going to see sort of incremental change to move to a sort of slightly revised basis of environmental assessment, and habitats. It's really up for grabs. I don't quite know where we're going with that.
Yeah. Natasha, do you want to add anything to that?
No, I have nothing to add, and I completely agree with what Richard has said in response.
What about Dole's question in relation to how the environmental principles policy statement should be applied either generally or in policy making, bearing in mind the potential tension between that, because of course that emerged from an attempt to plug the gap as a result of Brexit from the loss of the supervision of the Commission, but perhaps doesn't sit so happily with rule.
Yeah, I mean, it's interesting, and I personally think that this might be one of those sort of litigation traps that ministers might find themselves walking into. There is a binding obligation to take account of those principles in the formulation of policy, and that means that certainly when you're dealing with ministerial decision making, there is going to be argument potentially about whether those principles have been taken into account, but they are each framed at a fairly high level, each of the principles, and the statutory statement is also framed in a fairly high level way. So yes, a new legal duty, but perhaps not one that the court is going to think is a particularly sort of sharp one in terms of enforcement.
Just an interesting question here, and since there've been no heritage questions, Rupert, I think I'll just wake you up and see if you'd like to have a go at this one.
You rotten.
It's slightly Charles' area, and Charles, of course, can chip in as well. But the latest of the questions relates to a Section 73 application against a Reserve Matters application. And whether that in fact is a correct approach at all, and if it is, whether it results in a new planning permission.
Yeah, it's an interesting one because obviously Section 73 by definition relates to the issuing of a new planning permission, and Reserve Matters approvals, again, by definition, are not planning permissions. But I think there's the way that this tends to be approached, I think, is by reference to analogous case law on 96A. So the cases of Fulford Parish Council, which was one about Stamford Bridge battle site, and Pressland, where the analysis to allow conditions to be to allow Section 73 to be used in relation to those was that there's a package, I think was the expression that was used by the court in Pressland, which is the overall consent, the outline and any conditions, and the reserve matters and any conditions. And so it followed from that that one could, it said, apply conditions in relation to reserve matters applications, and therefore one can apply for Section 73. What it means, I think, is that you'd end up, on the face of it, with a reissuing of the whole permission. So prima facie, the whole outline plus conditions and the reserve matters plus conditions, even if it was just a change to one of the conditions on the reserve matters. But there isn't a case directly, I think, on Section 73 and RMA.
I mean, it just struck me as it might be open to question whether it was the correct approach anyway, because I mean, the law is very clear, PowerGen and lots of other earlier authorities, that if you've already implemented your permission, you can get as many reserve matters approvals as you like, effectively, and vary what you're seeking in the reserve matters approach.
Yeah.
But it seems to me it's going to be an odd case where you use Section 3 to vary a reserve matters approval, when assuming you've implemented within the time limit and you've still got the time available for an RMA to be made, you don't just apply for a new RMA.
And it may be that I think I saw another question that somebody had kindly posted, which related to somebody making a reserve matters application out of time. Obviously, if the time for commencing and the time for making RMAs, obviously in theory as many as you like, has elapsed, then making a Section 73 to tweak something on an RMA that was granted in time would probably fall foul of the provision in Section 73(5), I think it is, isn't it, which says you shouldn't use it to extend the time for implementing. So I mean, that would be an example potentially of somebody using it to try and get around the limitation period.
I brought a judicial review against a local authority who tried to grant reserve matters out of time, and they threw the towel in.
Yeah.
Charles, is there anything you want to add to this?
No, nothing. I agree entirely.
In which case, Rupert, James has taken pity on you and asked you a heritage question. Can you expand on the exclusion of the setting of conservation areas in the new Act? And do you think this was an error?
Well, pass, I think, on whether it was an error or not. I mean, it's not there. I don't think it was an error. I think they gave fairly detailed consideration to protection of SAMs and wrecks and battlefields and RPGs. I think the trouble with expanding Section 72, if you like, or statutory protection to the setting of conservation areas is how many of them there are. And there was quite a lot of debate in consultation and consideration about that. But I don't think it's the position is it's not there. It's not in force, obviously, at the moment, that new level of protection for those other settings, but conservation areas aren't included.
And given that they're rather more widely drawn than other heritage designations, such as listed buildings and scheduled ancient monuments and the like, you might expect, I suppose, to a degree, anything critical to setting might already be included in the conservation area itself.
You'd hope. I mean, obviously that we're used to dealing with all of that under the framework, and often the answer is, well, not in this case. But I think that's right. I think it follows that's the division that was always there in the Act between Section 66 and 72, and they just carried that on.
Right. Joe has thrown in a random. Well, it's not a random question. That's very impolite of me. Joe's asked about the eco advocacy case, and James Marici's blog saying it wasn't a major retreat on people over wind. Since I've been involved in considering that recently, and others may want to chip in, I'm just going to say this. For my own part, I think James is right, because it was always a moot question as to how far mitigation measures were inherently part of the project, and therefore fell foul of people over wind, and could you therefore separate key aspects of a project from mitigation when they're already part of the measures? And all the court has said in eco advocacy, of course, is that something which is normally or to be expected to be part of the project isn't mitigation for the, and you don't have to proceed to appropriate assessment. Does anyone have thoughts about that?
I agree with that. I think James's summary, which I just reminded myself of, I think I remember he quoted Churchill, which seemed all a bit improbable in the context, but I think he described it as his view of people over wind lacking common sense, and that this was a sort of minor retreat, but he thought that eventually we'd get to a position where people over wind was no longer part of the law. And I certainly think that if we were to sit down and rewrite the habitats regulations, we'd probably take the logic of Mr. Justice Sullivan, as he then was in heart, and apply that, because it makes a lot more sense than the slightly strangled position we get to through the people over wind analysis.
Joel, do you have any views?
No, I completely agree with that. I don't think I have much more to add on that.
Can I pick up Kate's question about a development which has been implemented? Reserve matters have been granted unlawfully out of time. How might you remedy the situation, particularly if you're advising a site purchaser, other than saying perhaps you might think about not purchasing it or cutting the purchase price? But thoughts about that particular problem and how you might address it? Charles, do you want to kick off?
Well, I mean, Kate has said here Section 73 cannot be used because it is unlawful. Is insurance the only option? I mean, just to sort of backtrack a bit, the reason why Section 73 couldn't be used is because, and there's another question here, which is, can Section 73 be used retrospectively? Well, I think the answer is it cannot be used retrospectively to regularize a breach of planning control. It can be used in respect of development which might already have begun, but so there's different ways in which you might mean retrospectively. But I think, I mean, you could just make a general retrospective application for planning permission. I don't know why you would have to use Section 73 for that.
Yeah, I agree with that, David. I think that's what I'd advise probably in a situation like that. If there were, you know, houses that have been sold or units that have been sold and people were worried about the status of the consent, there is case law obviously on the scope of a retrospective application under Section 73A. Yeah. Obviously it's a new consent, so questions may arise about whether one has to revisit all the 106 obligations and so on. But if it's all been built, then the case law, I think, indicates that one should be fact sensitive about the scope of a retrospective application. And if that's all been done and the 106 monies have all been paid, etc., it would seem to be unlikely that you'd be able to revisit that kind of thing. But that would be the obvious answer, I think, to the question.
Although you do have in that context, don't you, the Sister Christine Frost decision of the then Mr. Justice Keane many moons ago, which basically says Section 73 being a new application, you have to apply planning material considerations as they stand at the date.
Yeah.
So it might require a bit of nifty footwork to avoid the consequences of that.
Indeed. Yeah.
I'm just trying to see whether we've covered most of the points. Let me just check. Someone raised the point about the hillside judgment in relation to reserved matters rather than Section 73. I think is the last question. Charles, do you have a view about that?
I'm not sure. I'm afraid what the exact question is in relation to that. I wondered if that was maybe a response to the discussion earlier about reserved matters application. You were using Section 73 application against reserved matters approval. I think that might be it might be a comment about that. I'm not sure.
Right. Well, I think one final question, and then we'll wrap up. I think this is a question for Joel, which says, and anyone else can chip in, of course, can an outline permission which allows phased reserved matters, do you have to carry out an appropriate assessment if you're doing a subsequent stage FRI type appropriate assessment? Can you just do it for that reserved matters, or would it have to consider the entirety of the scheme which is subject to the outline planning permission?
So if I understand that right, you've got a multi-phase scheme, just as you did with CG FRI. You've not carried out, sorry, you have carried out an appropriate assessment at the beginning, at the outline phase, and then you come back with an application to the reserve matters phase to discharge conditions. And the question is, well, you know, do you need, forgive me if I'm misunderstanding this question, but do you need to carry out an appropriate assessment, a full appropriate assessment again?
I think it's, can you carry out a staged appropriate assessment? So can you just confine it to the phase of the reserve matters that you're doing, or do you have to include all of it?
It seems to me that the important point is that at the final stage, at least, at the consent required in order to implement the project, if it's likely to have a significant effect on a European integrity site, by at least the final stage, there needs to be a full appropriate assessment having been carried out, assessing the entire project. Now, I'm not sure actually as to whether or not you can do it as in terms of a phased approach. It's an interesting question. I'm not completely sure.
I have to say, I think I personally would err on the side of caution, because if the sign off of the reserve matter is to allow the project to proceed, question whether you can then exclude parts of the project at that stage, because you'd only be assessing part of the project rather than the whole project. And the planning permission, which gives consent to proceed, is the entirety of the scheme, including reserve matters applications and any discharges under individual conditions. So I'm not sure you can necessarily divide up a scheme according to reserve matters phases. I mean, it might be one thing if you're amending for a particular phase as opposed to a completely new appropriate assessment. But it would be a curious concept that you could only do an appropriate assessment for part of a the scheme. I'd certainly be worried about that.
Yeah, I think I'd agree with that. CG Fry doesn't necessarily make that point clear. All we know is that when the claimant there did try to argue about limiting the scope, despite this being kind of the final implementing, I think, reserve matters consent required, the court rejected that and said, well, you haven't done one before, and you are going to have to assess the whole scheme, including the impact of the conditions here at the end.
Well, I think we'll draw matters to a close there. We'll check the questions, and if there are any questions that we haven't directly answered, perhaps we can send something out when we send out slides and the link for the recording. But can I thank everybody for taking part, and can I thank everybody for attending, and see you at the next seminar. Thank you.